Good morning. Welcome back to the Retirement Report. I'm Hank Parrott, your host. With me, my good friend and special guest, Jack McCann with McCann and Hubbard over in Cool Springs area. He's right near the mall there. One of the things that Jack, in addition to estate planning, as we've been talking about this morning, he's also a real estate attorney. He handles closings on real estate. He can help you with if you need purchase and sale agreements, if you've got a for sale by owner, which is these days the market's so hot, a lot of times that happens. He can be a big help there to you as well, and other matters related to real estate. And then on the estate planning, as we're talking about, one of the areas when it comes to estate planning, and it can be so important, and we don't think about it. We think of estate planning, well, I need to get a will, and yeah, maybe a power of attorney and power, because think of things that if you remember, if you've been around long enough, right, and most of you listening probably have, Terry Schiavo. Remember that case down in Florida, and this situation, simply because they didn't have a living will and power of attorney for health care, that it ended up in court and the families fighting about what to do with regard to Terry and whether to have her on life support the way they did or whether to let her go. All the back and forth and all the unfortunate decisions that had to do with maybe Social Security or insurance payments and money type things, and her wishes, whatever they may have been, were being argued back and forth as to what they were, because they hadn't been put down on paper to where it could be right there for all to see and to follow. So that's an example of just the importance of two very simple documents: power of attorney for health care and a living will. Now, and that's going to be two of the documents, rather, as a part of any good estate plan. The next piece would be a power of attorney for assets. And Jack, this is one of those areas in how they can work, by the way, together, especially power of attorney for assets, that and the healthcare directives, as well as then a trust. In particular, if when you're dealing with someone becomes incapacitated, and again, husband, wife out there, if you think just because, whichever one or both of you have maybe retirement accounts, 401ks, and one of you, God forbid, a car accident, it could be any number of things, or maybe it's later in life, okay? And one of the common things that we might see there is where, God forbid, a stroke or that kind of thing happens, and now a spouse is having to take care of you, but it's more difficult to do if you don't have any documents in place, if you haven't set forth your wishes, if you haven't had these kind of discussions between yourselves. And in particular, as far as just dealing with the basics of the day-to-day living and access to money that you need, in particular retirement accounts. If you're talking about, if I'm married and I got my wife's got a retirement account and she's has a stroke and can't communicate, she can't she can't do anything about getting that money, and I can't get her money without having at least a power of attorney for assets. Right. And even more important would be in addition to that would be that of maybe to help administer everything as a trust. But Jack, this is one of those areas that in that scenario I just was laying out, you'd have to go to court and be appointed conservator, and you've dealt with that kind of thing.
Absolutely, we have, yeah. And that's one big argument in favor of a trust over just a simple will. A will is taking care of your assets after you pass away. A trust can be used also while you're still alive. So we all know families where somebody has become incapacitated at an older age because of Alzheimer's or a stroke or something like that. And the advantage of a trust in that kind of situation is you've already got a plan in place to take care of you, and you've named the people that you want to take care of you. And the good news is you've got maybe your spouse named, which would be a logical thing, but you've also got the backup. And you may have one child who's just much better at managing things than another, or you may have a family friend or a sibling that you feel would be a much better person to manage your affairs and take care of you. But a revocable trust is there to take care of you, and it's not until you pass away that it takes care of the remainder of your family. So what we were talking about during break was the difference between using a trust versus a conservatorship. Conservatorship is sort of like going to probate while you're still alive. And when we go to conservatorship, somebody's petitioning to be in charge of your personal affairs and your financial affairs. And so it's very similar to probate, but you're still alive, and the court designates somebody to take care of your assets, take care of your person. The problem is that conservatorship is a very expensive process to go through. I would tell you it'd be at least $3,000, $3,500, if not more than that, versus getting a revocable trust plan, which may only be $1,000 or $1,200. maybe $1,500, but still going to be half what it would be to do a conservatorship. And in the meantime, I mean, not in the meantime, but with a trust, you as the grantor are saying, here's who I want in charge, here's how I want them to manage my affairs for me, versus a conservatorship where you've got no say-so in the matter. It's somebody else petitioning saying, here's what we think that she might have wanted. And that goes right back into the Terry Schiavo case where nobody knew what she wanted. And that was a 10-year court case. It was horrible. They spent an incredible amount of money arguing over what she may or may not have wanted. And she could have done a simple estate plan and had her health care power of attorney and her living will in place, and there wouldn't have been any argument.
Yeah. This is one of those areas. Now, typically husband and wife, the spouse is going to be the one petitioning the court and most likely is going to be granted that, but not always. All right. I had a situation years ago where the children actually were fighting with the father over who was going to be conservator over mother. Okay, and the children were contending that father wasn't able to properly care for her, maybe because of his own physical condition, all right, or his own state at that time. But they literally the family ends up in court fighting over this, and this is where what Jack was just saying, as far as $3,000 to $5,000 can get quite a bit higher if you imagine now needing attorneys to get into almost a litigation type of thing in the court. And then you're going to get doctors involved to, talk about what's dad's condition or what, and his mom needs someone appointed. And in this situation, the children were contending maybe dad needed someone appointed for him, that he had days when he wasn't doing so well. So it can be a real mess if you haven't already set these things up in advance as to what your wishes are. And when we do this kind of estate planning, not only are we saying, well, I want, if something happens to me, I want my, let's say my wife to take care of those things, or my husband to take care of those things. But what if they can't? Then you would have a backup. You're saying, okay, well then I'd have this person. If they can't, I'd have this. So we typically will have 3 people lined up, your primary and a couple of backups, and sometimes they can be joint, sometimes it'll be just in order. And typically with most families it's going to be adult children, but sometimes it's a family friend or someone else that they may appoint. And sometimes if someone doesn't have anyone, and maybe that's another concern, it's like, I don't know who I would name. I don't know what to do there because I don't really have any close family members, or I don't really have any close friends that I could ask to do that. Well, then maybe we get into a corporate trustee, and there's a need for that. And for you, in fact, it may be even more important, because who's the court going to appoint? Right? Who are they going to name to do those things? So getting all your wishes lined up, and you can also state what you want someone to do for you and what that would look like. And you can get advisors lined up within your document that say, hey, like in my office many times serves as an investment advisor on these, for my clients on their documents. So you can name who you want, and you can have, people lined up for advisors to help the people that you're naming to these different positions as well. So again, it's better to have a plan than no plan. What's that old saying about failing to plan is planning to fail? All right, let's not be in that position, because it's only going to be more expensive if you haven't taken care of it. It's always going to be a lot less expensive to handle up front. What's that? Pay me now, pay me later, right? Be proactive and get those things done. All right, so conservatorship is one of those areas for doing, it's a good reason to do it up front. And again, we talked about power of attorney, but the way a trust works is that you're basically transferring assets into the trust. Now, the trust, a revocable living trust, it operates under your Social Security number, so nothing's changed in your day-to-day dealings of how you do your business or filing of taxes. Nothing's changed, okay? In fact, you wouldn't know that was even in existence, all right, but as far as any changes to what you normally do and what you do today. However, when something happens, when there's a triggering event, that's where it's all in place and is able to do what you intended to do, and it makes it a lot easier for those family members to administer everything if we've got that trust set up than if it's not set up. So, Jack, one of the other areas you'd mentioned that other states like California and Florida, if you have property in other states, this is another area where you can end up with multiple probates potentially if you don't have any planning. That's
true, yeah. You're going to do we have to do probate every place that you've got real estate. Now, if it's all within the state, then we're only doing one probate. So if you live and die in Davidson County and you've got a condo up in Pigeon Forge, that's all right. We're just doing one probate. But if you live in Davidson or Williamson County and you've got either property you've inherited in Alabama or Mississippi or Arkansas, or you've got a vacation property on the lake in Alabama or a hunting lodge in Arkansas, we're going to have to do probate in 2 different states. And if you, again, one of the advantages of a trust is if you've got those properties, we can put those properties into that trust. Well, the trust doesn't die. The trust is a management vehicle that continues on after your death. And we can say within that trust what you want to have happen to that property, or we can say in that trust who you want to be in charge of deciding what happens to that property. But in either case, the trust doesn't die. If the trust is the owner of the property, then we don't have to deal with any kind of probate. It just becomes a management decision. And that trustee has the authority and power to quitclaim that property onto some other heir, or to sell it and use that money for your heirs. So there's a lot of, there's much better control and a much better planning process when we sit down and talk about doing things like that through a trust.
And this is one of the areas when you're looking at a trust, it's so much easier, right, in terms of administration compared to that of going through probate. Now, when I say easy, I don't mean, you know, for the person that you've named as executor or executrix of your will, they're typically going to be working with an attorney to go through the probate process. So there'll be some expense to that. There'll be, typically it takes about a year to go through probate. So there's a process involved that is a little more, well, basically, again, the attorney's doing most of that, and there's the courts involved, and there's some, basically, mainly the delays, I guess, more than anything, compared to that of a trust, which is more immediate. And we'll explain how a trust works in that situation when we come back. But first, we got to take a break. Join us here. We'll be right back on the Retirement Report.